Former Kaduna State Governor Nasir El-Rufai has filed a 10 billion naira fundamental rights suit against the Independent Corrupt Practices and Other Related Offences Commission, ICPC, over alleged denial of family access while in custody. El-Rufai, through his lawyer, Ubong Akpan, filed the case at the Federal High Court in Abuja on August 13. He joined the ICPC chairman and the Attorney General of the Federation as defendants. The former governor alleged that ICPC officials prevented his wife and son from visiting him and supplying food, medication, and other necessities. He also alleges that officials physically restrained and intimidated the pair. El-Rufai is asking the court to order unhindered and reasonable access to his family and counsel throughout his detention. He is also seeking 10 billion naira damages over alleged violations of his constitutional rights. To discuss this, I'm joined by lawyer Osigwe Momoh. Thank you for being here with us. Let's talk about the violations that El-Rufai is alleging. Is he correct that the denial of access to his family is a denial of his fundamental human rights?
Absolutely not. I mean, that would be a stretch. I think the entire chapter 4, which has to do with the fundamental rights of Nigerians or anybody in Nigeria for that matter, I think it has to be read in concert. You can't just extrapolate a tiny part of it and run with it. You know, there's also Section 35, you know, which we'll have to do with. Sometimes when you're being held, you can be detained and is being lawfully remanded. Sadly so. I personally have said repeatedly, even in this station also, that I'm not a big fan of the current bail regime that we have in Nigeria. However, that's the law we have now. Once you are detained, once you are being charged, you can be remanded until the trial is dispensed with. And I think that gives rise to a lot of abuse as it can. But is it lawful? The answer is yes. Is it proper? That's the conversation that should happen, happen another day completely. But to say that denial to counsel is different. You have a right to talk to your lawyers as often as you can, pending the matter. But to say your family, and also realizing that part of the reasons why the court want to keep you in is so that you don't meddle with the fact, you don't distort the ongoing investigations, even though the matter is still in court, and and all that, and probably commit, try to hide more evidence in this matter. So the courts and even the officers can say, oh, we don't want you talking to some members, of your family who we think may help you to probably be accessories after the, fact, add to the offense in one way or another. So that's a stretch to say that.
Well, this is not the first time we're seeing such a case being brought before a court of law. The alleged fundamental, the disrespect of fundamental human rights. But can the court in this case compel the ICPC to perhaps allow the family and legal counsel? You said that of legal counsel is understandable, but do you think the court can compel the ICPC to allow the family visit?
I mean, fair, but I'm generally speaking. But I think one of the fundamental rights is asking for is a fundamental right to be a big man. And that's not in the 99 Constitution as amended. So you're going to ask several other people, when you're saying that right now, this is not a person that's been convicted. They are saying, the prosecutors are saying we need to keep him so that it doesn't delve and meddle in hide more evidence. And they feel like the family may assist him in one way or another, give him information that will hinder the further investigation, because clearly they still say they need further investigation. So it's basically saying that you're tampering with such investigation, and that's not going to fly in here. There's no way you will say because you have a right to medical, which is fair. You can always have that in the facilities as we have it. Sadly, there's a Nigerian medical facilities that we all deal with. So I don't think the court will insist that I should see his family. It's not. It's not part of our laws in any way you look at it. It can be.
Okay, go ahead. Finish your thoughts, sir.
Sorry. Yes, yeah. So there's a lot of discretion that the courts may look into, but at the angle I think the court is going to be looking at more is, will this in any way hamper further investigation by the prosecutors? That's all they need to say, is that we don't trust that the families are not going to be giving him secrets, are not going to be helping to stifle the ongoing investigation. And that's all that the prosecutors have, or the state has to say. And it will be difficult to upturn the current position.
I don't know if this is strictly a legal question or if there's a legal explanation or action that can be taken when he alleges that his wife and son were restrained and physically restrained and intimidated on July 7 when they attempted to visit him. Is there a legal angle here? Can the wife and son pursue legal action? Is he right to pursue legal action on their behalf? And what should be a proper conduct in cases like this, where family is being denied, when an accused is being denied access to his family?
Yes. So again, denying access to his family, typically in your home, you're fine. I think that's where they're running under Section 37. Interestingly, it doesn't just cover family. It almost seems like a parody, because it also covers, telephone conversations and all that, another offense where he's being charged with the DSS, So while the state can say typically a man should have access to his family, it's okay, you're being detained, you're an offender, that doesn't stop you from, having associations. But like I'm saying, the entire chapter 4 must be read in concert. There is 35. 35 is very important. The state can say, unfortunately, we cannot allow you have family to bring food for you, for example. We don't trust that they're not going to poison you. That's the discretion. So once a person is being properly held, how he's going to be held cannot be deemed to be against his fundamental rights. You can't just close your eyes to 35 and rely on 34 or 37 like they're trying to do now. 35 is there. So how do you trump 35? I think the emphasis generally has to be that this man has been held for so long and he ought to be released, and not, fighting or playing around technicalities.
Right.
He's still innocent, is still presumed innocent for whatsoever reason, and it's bad. The general outlook doesn't look good for Nigeria. It seems as though it's a political matter, even though there are glaring cases where, how is he going to run away from what he said, that he's tapping into the foot of an NSC officer?
Osigwe, thank you for speaking with us.
My pleasure, please. Thank you so much.